Take a most.
Some 29. In this case, my he's in custody since 2006. Date may be fixed for hearing.
Why are you not filing the bail application?
This is a case of Mr. A.K. Patnaik, not mine. My name is there.
You file, you are having power. So
If my lord direct me to.
there is no question of direction. You have been entrusted with a brief. It is not only for arguing the case finally.
This is the legal and brief. They interested
It be legal and brief. Upon bail application file करके मना करिए कहीं bail टा file करे. You file bail application.
It is inherent with you. You can't say that I will not do this, I will do that.
Brief has been entrusted to you, so you have to do it.
In the interest of
justice. No, it is also part and part. You a person is having so many years in custody,
yes,
and we are not able to take up this matter in spite of the preparation of the paperwork. Then it is your duty to bring it to the court and file an application for bail. So, yes.
Supplemental list, item number 1.
IA number 16.
File an application tomorrow, not today. Yes.
My lord, IA 16,793/2025. I filed this IA. This is a sufficing matter, my lord.
Mention it tomorrow.
Tomorrow, sir, this is special bench. Mention it tomorrow.
My lord, tomorrow will be the election.
No. Yes, next.
Supplemental list, item number 1.
May please the lordship. Non-compliance of the order dated 3/10/2024. This content has been filed now.
Come to the operative part of the order. Page number 11.
Yes, my lord. Considering the submission made by the learned counsel for the petition, without expressing any opinion on the merits of the case, we dispose of the writ petition, directing the petition to file a detailed representation before the opposite party, highlighting the grievance within a period of 4 weeks from today, and in case the petition filed detailed representation, the same shall be disposed of by the opposite party in accordance with the law within a period of 3 months from the date of representation, after giving an opportunity of hearing to the petitioner and communicate the result of such exercise to it within 2 weeks from the date of decision.
So this representation is filed when?
That's it, my lord. 22/10/2024.
But where is the documentary proof that it has been sent?
At Western Post, I have with the postal receipt.
No, if you keep it with yourself, you are satisfied. So,
Thereafter also when reminder I have sent.
no, whatever it may be. Why have you not annexed the receipt, the postal receipt?
In that reply, I have left it. I will file it in memo, my lords, in course of day.
Even in the paragraph number 2 also, you have not stated that you have sent it to registered post or speed post, whatever it may be. Just you send that you made representation. Now, suppose they come forward and say that we have not received or I have not received.
Then I have not, I will not know this.
That's why we must be satisfied that you have complied your part.
Yes, my lord, I have satisfied.
Or where is that? Please file it that.
Yes, my lord, I will file.
File it with a memo.
Memo, you will.
You want it to taken up some other day, or you are having that receipt with you?
I have, because the xerox copy of the receipt with me, my lord.
Where is the original?
No, I will do it.
What is about this? Because you have sent one representation and also reminder.
Reminder.
So are you having both the receipts with you?
Yes.
So file it. This content petition has been filed by the petitioner, Messrs. H'N'Ble Finance Private Limited, for non-compliance of the order dated 3/10/2024 passed by this court in WPC number 24575 of 2024. While disposing of the aforesaid writ petition, we pass the following order. Considering the date of decision. Averment has been taken in the content petition as follows. Quote paragraph number 2. When we made a query to the learned counsel for the petitioner, that what is the documentary proof that representations are stated in paragraph number 2 have been submitted before the contemner, either by registered post or speed post. And what is the documentary proof to that effect? He seeks some time till next week to file the documentary proofs with a memo.
Yes, sir.
Put up this matter on, it will come on Tuesday,
Yes, sir.
23rd of September 2025.
Item 2,
My lord, this contempt petition is the non-compliance of the order dated 5/11/2024. Your lordship passed order directing to the,
You come to your prayer portion in the content petition.
it is therefore prayed that this.
Have you mentioned which order has been flouted? Which order they have not complied with?
Order dated 5/11.
Have you mentioned in the prayer portion? We are asking you a plain and simple question. You are directing, you are seeking for a direction to issue the consent proceeding. So are you not supposed to mention that for this particular order, non-compliance of this particular order, the content proceeding should be initiated?
My lord, in the government, I have in para 1, I have.
Once you take the averment, it is not required to mention in the prayer portion.
My lord, already not mentioned in my petition. Petition I have mentioned.
You see, when you are, the contemners are not, they are very, one is executive engineer, in the other case, somebody may be IS officers.
Yeah.
So the petition should be in proper format.
I have, this is a format, my lord. I have categorically mentioned in my petition, in prayer portion, I have mentioned to issue notice and take action as per the contempt protocol.
Amend the prayer portion, mention which order has been flouted. You have mentioned so many things in your, we have to see that which order has been flouted.
In
The current
the
council
petition, I have
will plainly and simply dismiss the petition. We are giving you opportunity to amend the prayer portion. The learned counsel for the petitioner seeks for an adjournment to file an interim application for amending the prayer portion of the content petition and specifically mentioning which order of this court in which application has been allegedly flouted by the contemner, opposite party contemner. Put up this matter immediately after the interim application was filed. Yes.
23rd, I shall amend the in meantime. 23rd.
Acha, this, put up this matter, list this matter on 23/9/2025. If an interim application is filed for amendment, the same shall be placed on record. Yes.
item 3,
Again, same thing,
Yes, sir.
same order for them. File. 23/9/2025.
Yes, sir.
item 4,
Please, your lordship, I'm there virtually. I have filed an IA for condonation of delay for substitution of the legal heirs of the present appellant, my lords. And I also filed an IA for
Just a minute. I
My
know
lords.
the combination of the CRL is on. So, this man was found guilty अच्छा।
394 record.
अच्छा, एक लगी order is
It's like 1908 to 25.
none of the near relatives wants to sponsor.
No, that is.
Other than accordingly disposed of, the near relative wants to challenge the company is at liberty. Acha. So who are these IA
Near
petitioners?
Well, it's the petitioner number one is the wife of the appellant, and the others are the son and married daughters of the appellant. One A is the wife, Millards, one B is the son, and C, D, E are the married daughters of the appellant.
There is
I've
no
also
three.
annexed the
What is the
legal
three?
heir.
The IA is IA number
Millards, may kindly have a glance to IN number
2508.
2508.
Acha, okay, please.
And next to B is the legal heir certificate.
Death certificate, legal heir certificate. These all these legal heirs are the now the 1A, 1B like this.
My lords.
What was the petitioner, by the way, appellant?
The appellant was serving as the postmaster, Millards. That is what. He was having a service.
You have not stated anything. Why you want to continue this? There is nothing written.
Millards, the service benefits of the
No,
appellant
you
are
should have mentioned it. Otherwise, matter the man goes. Why we unnecessarily would exercise it?
Millards, I'll place those on records after taking instructions.
The IN number so and so. Mr.
I may
Panda,
be permitted to amend that IM. Millards.
the interim application for substituting filed by the legal heirs of the deceased appellant for substitution. During course of argument, Mr. Panda, land counsel submits that he intends to amend the interim application. So, put up this matter immediately after the amendment application is filed. Yes, next.
I'm grateful, Millards. Deeply okay.
Item 5.
Lord, in item 5, my lord directed to obtain the health condition, financial condition, and criminal antecedent of the health condition good, financial condition poor, and there is no criminal antecedent.
There are two persons,
My lord,
appellant,
my lord,
who died actually.
my lord is
Plan number 2 has died.
appellant number 2.
Appellant number 2 died also. So this appeal has abated so far as appellant number 2 is concerned. Appellant number 1 name is Lingu alias Lingaraj Garji alias Viya.
My lord,
What order will pass?
9/9/2025, directed to for the health condition, financial condition, and criminal antecedent.
Perhaps there was some argument that it cannot be maybe not be a case under 302, and if it turns to either 304
My lord.
part 1 or part 2, then he has perhaps not remained for that period in judicial custody.
Only-
What is the period he is imprisonment? A trial court reporter. Have you verified it?
Arrested on 25/11/97.
Arrested on 24/11/97, my lord.
Just 20.
Forward hela 25/11/97.
97.
Released on bail 29/2000.
ନାଇଁ ଟ୍ରାଏଲ କୋର୍ଟରେ ସେ ଥିଲା ମାନେ
Custody ଥିଲା, my lord. He is not bail in trial.
ସୋ ଏଇ ଅର୍ଡର ହେଲା 29
2000.
2000.
2000 yes. So Not
Less
3
than-
years even. no?
less than 3 years.
देखिए, ये रहा। So in this case, eyewitness is there, PW4.
PW1 is the
PW1.
eyewitness.
PW1 madam.
1.
Not 4.
4 oral
Four is the-
declaration.
So this is PW1. Oral dying declaration before PW4.
1 and 4.
Acha. Eyewitness evidence from Austin.
PW6 also.
PW1.
Eyewitness, my lord. PW1. He
Come
stated that
to that.
PW1 page running page 48. While I was attending call of nature,
Good portion.
running page 48,
Paper book.
paper book.
Fine. Yes.
On that day, my father had been to
6 line.
Purna Sai.
Hmm.
On that date, my father had been to Purna Sai jungle to cut dead palm juice, and I had been to attend call of nature near to the plantation. While I was attending call of nature, on hearing sound of my father of saying, "Mate sahaଯ୍ୟ karo," I went near to my father and saw both the accused person chasing my father. Where?
You are reading PW1.
Yes, my lord.
ठीक है, पढ़ो. Chasing my father
My lord, chasing my father.
and
Were assaulting my
by Katti.
Katti on the neck of my father.
Hmm.
Both the accused person were giving Katti blow on the neck of my father.
Hmm.
When I arrived near to my father, both the accused person fled away. My father had sustained bleeding injury, fell down on the ground, and when I went and called my Dada Samsundar, then I, along with Samsundar, brought my father to our home. On arriving in the house, my father told my mother and other family members that both the accused person killed him.
Hmm.
In the same night, at about 10 p.m., my father died. In the early morning, while we were crying, both the accused person came to our house and told to dispose of the dead body immediately, or else they will kill us. The accused person also threatened not report at police station.
Not to report.
Not to report it. Then, out of fear, we disposed of the dead body of my father. After the occurrence, out of fear, I did not report the occurrence in police station and went to house of my uncle Sarathi Sabar to observe the obsequium. And thereafter, I came with Sarathi Sabar to PS and reported Exhibit 1 is my report when I have given my signature exhibit 1 by 1. The contents of the report were explained to me, and I admit the fact to be correct and put my signature.
So, apart from seeing the assault, he has stated that when they brought the deceased to the house, there this oral dying declaration was made.
Yes.
And this deceased told to his wife
And family members.
and other of course
Yes,
that both the deceased killed him. So-
yes.
And what has been elicited in the cross-examination?
PW4, my lord.
Yeah,
No, I think
one.
one Saram, eyewitness is dying declaration overcome
Madam.
Yes, and also threatening to dispose of the dead body for which the dead body was disposed of. Yes,
PW in chief inspector, we all are present. But in the threat part, my lord, but none of the except the PW1 are stated in this thing, my lord.
Hmm.
Thereafter, in his cross-examination, he is stated immediately, my lord, soon before occurrence, he has attended the call of nature. None of the except the PW1, these things are have stated before this case, my lord. And thereafter,
Where he has not
also
stated?
he-
Where he has not stated?
he-
About
except PW1, my lord,
ah,
these things are
who else
nobody-
can say about it? He's gone to
He has-
attend the call of
He has
nature.
not stated anybody to attend the call of nature.
ସେ call of nature
Including-
ଯାଇଥିଲା ବୋଲି
As say, ଆଉ ଅନ୍ୟମାନେ କହିବେ କେମିତି? How
ନାଇଁ,
you expect?
ଘରୁ ସେ କହୁଛି ମୁଁ ଘରୁ ଆସିଲି କିନ୍ତୁ
ହଁ,
କିନ୍ତୁ ହି ଷ୍ଟେଟମେଣ୍ଟ ଘରେ କହୁଛି ମୋ ମା ନଥିଲା କିନ୍ତୁ ମା କହୁଛି ତା ଷ୍ଟେଟମେଣ୍ଟ ମୁଁ ଘରେ ଥିଲି ଆଜ୍ଞା।
ସେଇଟା
ତାପରେ ମୋ ଦାଦା ଥିଲେ ତା ପିଲାମାନେ ଥିଲେ କିନ୍ତୁ ଦାଦା କହୁଛି ମୁଁ ମୋ ଘରେ ଥିଲି ସେପାରେଟ ସେଠୁ ଡିଷ୍ଟାନ୍ସ 2 କିଲୋମିଟର।
how do you overcome the evidence of PW1? ସେ କିଏ କଣ କହିଛି ନ କହିଛି that's a
ତାପରେ
substantive evidence
again
ଆସୁଛି।
again my lord, this thing occurrence happened 5 p.m. and his father died 10 p.m. He has not any kind of made attempt to shifted hospital nor
What-
reported the
What
In
Pranab,
cross-examination,
Pranab,
PW1
Pranab,
stated that
cross
it was evening time. It was evening time. There was slightly dark.
କୋଉଠି ପଢୁଛନ୍ତି?
Cross-examination, my lord, paragraph 15,
15.
my lord. Last line.
Hmm.
It was evening time and there was slightly dark at the time when we brought my father.
Okay.
late evening.
It was a winter
winter
season.
season.
Yes, winter.
ହଁ।
ଜଙ୍ଗଲ ଏରିଆ winter season.
ଆଉ ଗୋଟେ କୋଉଠି ଅଛି ସେ ଯେ ପାହାଡ ଗୋଟେ ଟପିକି ଯିବାକୁ ପଡିବ ବୋଲି କୋଉଠି କି ଗୋଟେ କହିଥିଲା।
ଅଛି ସେ paragraph 17.
Hmm.
I did not go to police station in the evening of the occurrence
Hmm.
when all the villagers came to my house. I did not call anybody to go to police station in the evening of the occurrence. We did not bring my father to hospital since we had to cross hills in the night.
Hmm.
There is road from Khajurpada to our village. In the following day morning at about 6 a.m. we disposed of the dead body. When the accused person threatened me and I could not tell anything to the villagers.
So it is you who has put some questions and the explanation has been given that why he was not taken to hospital, why he was the matter was not informed to the police, and the time is such, the place is such that there was risk to their lives, and there was no other thing as it appears available like ambulance service or etc. to take them to.
PW1, PW1 when crosses in para 2,
Hmm.
stated the village Lanjipura situated in your distance, it takes 5 minutes to reach bus stop to
no,
Lanjipura.
ବସ୍ ଷ୍ଟପ୍ ଥାଇପାରେ କିନ୍ତୁ ବସ୍ ଆସୁଥିଲା ବୋଲି କାହିଁ?
No,
There was a bus.
factor and also communication ଅଛି ବୋଲି ସେ କହୁଛି para 2 ରେ and also IOB has stated that there is communication with other
କେବେର
communication.
incident ଏଟା?
Don't forget that it was Rayagada and that too in the year
1999.
1999, and they were staying in a remote village where hills are there, and even to come to the hospital they are to cross a hill. So you are expecting as if they are residing in a urban area where 5 to 10 minutes bus services are available.
This is a remote village. All the villagers also be available, my lord. It is not any kind of attempt, my lord. His father is situated in very serious condition. He has
That is
not
the
any
way
kind
of
of attempt
life.
to.
In such areas, that is the way of life. They just keep mum. They have no other way. unless they carry them in the court.
ଭିଲେଜର ଠୁ ବି ହେଲ୍ପ ନେଇପାରିଥାନ୍ତେ 5 ଘଣ୍ଟା ଆଜ୍ଞା ବାପା
କୋଉଥିରେ ନେବେ?
କୋଉଥିରେ ନେବେ କୋଉ ସମୟରେ ନେବେ ନିଜ ଲାଇଫ ପୁରା ରିସ୍କ ଅଛି ଜଙ୍ଗଲ ଭିତର ଦେଇକିନି ପାହାଡ ଟପିକିନି ଯିବ ଆପଣ ଯେତେବେଳେ ଗୋଟେ କେସ୍ କୁ ଆସେସ୍ କରିବେ ସେଇ ପୋଜିସନ କୁ ଚାଲି ଯାଆନ୍ତୁ ସେଇ ସମୟକୁ ଯାଆନ୍ତୁ ତାଙ୍କର ସିଚୁଏସନ କୁ ଦେଖନ୍ତୁ ତାହେଲେ ଜଣା ପଡିବ ଯେ ଏକ୍ସପ୍ଲାନେସନ ଟା whether it is acceptable or not. ଯୋଉ ଗାଁରେ ଗୋଟେ PHC ନାହିଁ ଯୋଉଠି ପାଇଁ ତାଙ୍କୁ ଗୋଟେ ମାନେ ସେ ଲୋକମାନଙ୍କୁ ପାହାଡ ଟପିକିନି ଆଉ ଗୋଟେ ହସ୍ପିଟାଲ କୁ ଯିବାକୁ ପଡିବ ସେଠି ଆପଣ ଏକ୍ସପେକ୍ଟ କରୁଛନ୍ତି ତାଙ୍କୁ ନେଲେନି ସନ୍ଧ୍ୟା ହେଇଯାଇଥିଲା ଅନ୍ୟ ଗାଁ ମାନଙ୍କ ସହର ଇଏରେ ନେଇଯାଇଥାନ୍ତେ
So despite
any kind of attempt ନାହିଁ
no, then you should have come with some more questions. That there were 3 bus after 5 o'clock and you had opportunity to take the person to the hospital. The hospital is at a distance of this place. There is no need to cross the hill. So all these things could have been brought by you. In absence of all this, the explanation has to be accepted. You could have brought some more material in it. Despite the opportunity, they did not avail it. Meaning, they did not like to take the body. Their carelessness could be there, negligence could be there.
Day after occurrence, he had not been attend to buried in the father Melo.
Who?
And the PW1
He did not attend.
attend to
buried the father.
ମଲା ମରିନି କଣ ତାକୁ ନେଇ ମାରିଦବ ନା
Day after occurrence ହେଲା
Day after the occurrence, what happened?
ମର୍ଣ୍ଣିଂ ରେ ତାକୁ
ମର୍ଣ୍ଣିଂ ରେ ଡେଟ୍ ଟା ଯୋଉ ଡେଡ୍ ବଡି ତାଙ୍କର କଲେ ଇଏ ପୁଅ ହିସାବରେ ବି ସେଠି ବି ଯାଇନି ସାର୍
କ୍ରିମେଟ୍ କରିଛନ୍ତି ପୁରା ତାକୁ ମାନେ
ପାରା 19 ମାଇଲର
ରାତି 10ଟାରେ ଯୋଉ ଆସିକିରି ସେମାନେ ଧମକ ଦେଲେ ଯେ ତମେ ଆଉ ଥାନାକୁ
ରାତି
ଯିବ
10ଟା
ନାହିଁ ୟାକୁ
ଏଇଟା-
ଚଳେଇ ଦବ.
ମାଇଲର ଡେ in the early morning ମାଇଲର in a chief he has stated that in the early morning
How
while
it will
we are
ସେ କହିଛି
early
villagers
morning
have taken for ଇଏ ମୁଁ ଯାଇନଥିଲି
ହଁ.
এটা day after মাইলর morning মাইলর day after in the early morning while we were crying both the accused person came to our house. This third part none of the witness stated except the PW1 ମାଇଲର ସମସ୍ତେ ଥିଲେ କିନ୍ତୁ ସେ କହୁଛି ଆ ବ୍ୟତୀତ ଆଉ କେହି ସେ ଜିନିଷଟା କହିନାହାନ୍ତି in chief ରେ ମାଇଲର para 19 of the cross examination mail PW1 mail para 19 of the cross examination there is a separate burial ground in our village the villagers have attend the burial ground and the villagers gave
food and fire
on the fire about 10 to 15% attend the burial ground I did not go the burial ground my lord.
My brother, sister, mother were present
In the house, my lord.
when the dead body was taken. I went to my uncle on Saturday. I did not go to so-and-so.
Another part is my lord, lodging of the affair, my lord.
So there is no postmortem, obviously.
no
No, my lord.
This deceased was surviving till what time?
10 p.m.
10 p.m.
10 p.m.
5 hours
5 hours.
5 or 7. What happened to that kati which was used as the weapon?
No, it is not seized, my lord. I was not seized. And cross-examination, PW8 में the initial IO, cross-examination para 4 last line. I have not seized any weapon of the offense. I cannot say about the original owner of the Gudakadova. And also, para 2, he has stated that cross-examination, I have not seized any bloodstain yet from the house of the deceased. I have not seized any bloodstained cloth from the informant. I have not seized any bloodstained cloth from the Sarati Sabar. And I have not seized any wearing apparel from the Sam Sabar. Sam Sabar is the accompanying the PW1 to brought the dead body, my lord. And the chief has stated that bloodstain lagithala, kintu I was not seized.
But the witnesses who brought the deceased
Never.
from the spot to the house, like PW4, PW5.
No, PW1 and
PW1 and
PW1,
PW5.
5B Muddaman.
1 and 5.
Five.
Five, one.
And also 4 who is a
Mother.
witness to this. They have all stated that there was injury on the neck.
Yes,
That means it
Profound.
corroborates the oral evidence of PW1
yes,
that there was an assault on the neck.
yes.
That is,
So because PW4 has stated,
PW3, PW5,
3 is the independent witness.
they have seen the injury on the neck.
Yeah.
my husband was alive and when he was brought and there was caught injury on the neck of my husband. It also PW4 evidence.
Four.
PW5 ମଧ୍ୟ କହୁଛି Dumbai was alive when he was brought to home.
PW5 is
And
the
ତା ପୂର୍ବରୁ
Samsu
there was-
Sabar
Sam,
ଯେ ନେଇକି
ଯେ
ଆସିଲା।
ନେଇକିରି dead body ଟା କଲା।
right, right.
PW3 miler.
PW3.
PW3 a co-villager, on getting information, he arrived at the
He
What?
saw.
so I returned. I saw this is Dumbai Sabar was laying injured on his right side neck. There was cut injury in the right side neck of Dumbai Sabar.
This part has not been challenged.
Yes.
That no such injury is there. So the evidence of PW1, as we just said, that he has seen an assault on the neck of the deceased by the accused persons. That is getting corroboration, even though the PM report is not there, but they have stated that injuries are there on the neck.
PW3, PW6,
4,
6 weeks.
3, 4 and 5.
5, 6 also.
Acha,
6 मध्ये କହିଛି injury ଅଛି.
acha.
6 କହିଲା ଯେ oral dying declaration.
ନାଇଁ injury କଥା କହୁଛି ନା ନାଇଁ?
Yes, yes. I went to the house of the deceased and found 2 cut injuries on his right side neck. On being asked as to what happened, my brother Dumbai told that the accused person killed him.
No, he was also present then.
PW7. After hearing the occurrence, I went to the house of Dumbai Sabar and saw cut injury on his neck.
So 1, 3, 4, 5, 6, 7.
So if you have dealt blows on a vital part of the body, if we accept this evidence that the appellant and the co-accused who has died, they have assaulted by means of a sharp cutting weapon like kati, which has of course not been recovered, but the oral evidence is that kati was used on neck portion, which is, and the injuries have been seen by not only number of persons, at least 5 persons have seen. Apart from PW1, Mr. Nayak said that 3, 4, 5 and 6. And since the body was disposed of, therefore PM could not be held. Now, that is how the injuries position by doctor could not be ascertained, obviously. So how do you get over this evidence? One is eyewitness, second is dying declaration, third is noticing the injuries on the neck of the deceased. And apart from that, of course, threat is there. And your main contention is that seems to be that he could have taken to the father to the hospital and he could have reported the matter in the police station, but there was delay in reporting and not taking the father to the hospital.
So, but timely medical intervention is not there.
So that is, maybe that the blood loss may be one of the factor also,
Yes.
can be cause of death. That's,
In cross examination of Bidol 4
Why?
wife, paragraph 2. There was cut injury on the neck of my husband. The head was not severed from the neck, but
It
it
was
was
bent.
bent. He could not tell anything more. মানে খুব injury, the जो भाବରେ injury ହେଇଛି,
Severity of injury was there.
there.
It got one-sided, but not severe. Severe तो कुछ କଥା कहता नहीं.
ନେକ୍ର ବି କୋଉ ପୋର୍ସନ କଟୁଛି ତା ଉପରେ ଡିପେଣ୍ଡ
ତେଣୁ blood loss is a
Right side, ଦେଖୁଛ right side.
ହଁ vocal cord ଯଦି କଟିଯିବ କଥା ବି କହିପାରିବି।
Right side କଟିଛି, ସେ bent ହେଇଯାଇଛି।
ଆଚ୍ଛା ଏଇଟା ନୁହେଁ ଯେ ଗୋଟେ ଲେଙ୍ଗଦି ଡାଇଂ ଡିକ୍ଲାରେସନ ଦେଇଛି ଯୋଉଟା କି
ନା, ନା।
ଇମ୍ପ୍ରୋବାବଲାଇଜ କରିଥାନ୍ତା ଯେ ଗୋଟେ ଲୋକଟା ନେକ୍ ରେ ଇଞ୍ଜୁରି ହେଇଛି ବ୍ଲଡ
ଏତେ
ଲସ୍
କଥା
ହେଇଛି
କେମିତି
ଏତେ
କହିଲା?
କଥା କେମିତି କହିଲା ଖାଲି ଟିକେ ନାକୁ କହିଛି ଯେ ମତେ ଏମାନେ ମାରିଲେ ଦ୍ୟାଟ୍ସ ଅଲ୍। ତେଣୁ
Definitely vocal cord କଟି ନଥିବ, ନହେଲେ କଥା କହି ପାରିନଥାନ୍ତା।
ନାଇଁ ନାଇଁ
Right side ରେ specifically evidence is right side neck.
maybe it was also apart from other things blood loss
हाँ,
Is the
that
reason.
is there. ଯେହେତୁ instantaneous death ନୁହେଁ,
After
and
5 hours.
5 hours is a very substantial time
Ah.
to go for medical intervention. Is a BW7 is a अच्छा independent witness.
Yes.
People 7 is independent.
matter
It
was
was pre
reported
also-
in the police station on 23rd, obviously 4 days after.
Yes. To observe the obsequies, the PW1 went to Sarathi, where he disclosed. From the house of Sarathi, they went to police station.
But in prosecution, he stated that at the time of scribe of the report, Babu, police, Babu told me to scribe the report and I can scribe the report.
report was scribed by that Sarathi Sabha.
Sarathi, PW2. As per the instruction of the police, I.
Not the instruction, they said that you
Police
presented a
police have
written
told me.
report. It is not that police dictated and
No, police have told me and I, for the
we
scribe.
told that you present a written report and obviously Sarathi Sabha was with him and he asked and Sarathi Sabha's signature madhya achi and that has been marked also as exhibit 1/2 bodhe. And se lekhichi madhya Somnath Sabha kahiba prakare mu e report lekhi. And that man has been examined as PW2 also. He said 4 days after the occurrence, PW1 came to me and told that his father
Another point is,
just was murdered by the accused persons and not reported to PS. Then I told him to report the police station and on the instruction of Somnath Sabha, I scribed the report, read over and explained the contents to Somnath Sabha and put my signature and obtained the signature of Somnath Sabha. Exhibit 1 is the said report which I have scribed, so and so is the signature. So
What is the distance of
Another
police
one-
station?
another point is,
What was the distance of
20
police station?
distance police
20
station.
kilometers.
No, registration affair, the first information given by the PW 6, same day the occurrence. He has reported the incident before the policeman. The elder brother of the deceased man, PW 6 man,
Suki Savar.
para 4 man.
The occurrence, I had built to that village on that day to observe no archive. On hearing the occurrence, I went to the
Approval, it is not a fact.
found that 214.
Tukishore paragraph 4. It is not a fact that I have not seen the cut injury on the neck of my brother. I reported in the police station about the occurrence on the date of occurrence.
I reported in the.
Yes, it
about the occurrence.
It is sporadic statement. No?
Meeting out.
Police came to our village
On the very day, how can it be? On the very day he informed, on the very day the police has also come in the night and police did not seize it.
Another PW4 has stated in the day after occurrence, she and along with 8 persons.
because the police saw the dead body. On my son, the bar for nation.
I reported the case about the occurrence of the death of a police came to the village on the that day.
it is not a fact ଆରମ୍ଭ ହେଇକି ସେ ସବୁ ଲେଖା
ତାପରେ
ହେଇଛି।
ମିଶି ଯାଇଛି।
See, the and that ରହିବା କଥା ସେଗୁଡା
ଛାଡିଦେଲା ବେଳକୁ ତାକୁ independent ଦେଖାଯାଉଛି।
First two line it is.
problem is that after the judge
correction
report
ନାହିଁ।
signing,
Correct.
is must read it. କାରଣ ସେତେବେଳେ
Type
ଏବେ କଣ
writer.
କି 3ଟା monitor ରହୁଛି।
ହଁ।
ଗୋଟେ
We can correct
ଜଜଙ୍କ ଆଡକୁ, ଗୋଟେ ମାନେ ସାକ୍ଷୀଙ୍କ ଆଡକୁ ରହୁଛି ବା
ଓକିଲ ଦେଖିବେ
ଡିଫେନ୍ସ କାଉନସିଲ ଆଉ ଗୋଟେ ଇଏ କରୁଛି
Steno।
ଆମ ଷ୍ଟେନୋ କରୁଛି। ତ ସେତେବେଳେ ଫ୍ୟାସିଲିଟି ତ ନଥିଲା ନା, ତେଣୁ
ଟାଇପ ଥିଲା
ଟାଇପ ଥିଲା, ତେଣୁ ବାଡି ଦେଇ ଚାଲି ଯାଇଛନ୍ତି ସିଏ। ଆଉ ବହୁତ ସମୟରେ ଏକ୍ସଟ୍ରା ଲୋଡ ପଡିଲେ ଏ ଜଷ୍ଟ ଖାଲି ଲାଷ୍ଟ ସିଗ୍ନେଚର ମାରିଦେବେ। ଏଇଟା ହଉଛି ଆଣ୍ଡ ଦ୍ୟାଟ କଟି ଯାଇଛି ସବୁ। କାରଣ ଏଠି ଦେଖୁନାହାନ୍ତି ପୋଲିସ ସ ଦି ଡେଡ ବଡି ଆଣ୍ଡ ପୋଲିସ ସ ଦି ସ୍ୱାନ୍ ସୋ ପୋଲିସ 4 ଦିନ ପରେ ଆଇଲା ସେତେବେଳେ ଡେଡ ବଡି ପୋଡା ହେଇ ସାରିଲାଣି।
ବଡି ନାହିଁ କିଛି ବି ନାହିଁ।
That is also the evidence of the IO.
Yes.
ଯେ ମତେ 4 ଦିନ ପରେ ଆସିଲା, ମୁଁ ଆସିଲି ଆଉ ଡେଡ ବଡି ସିଏ ଦେଖିବାର ଆଇଓ ଦେଖିବାର କୋଉଠି ପ୍ରଶ୍ନ ଉଠୁଛି।
The PW4 we already stated para 5 in prosecution. Police
He
came to our
collected
village.
some bones from that was the cremation ground.
Yes.
And ସେଥିରୁ କିଛି ମିଳିଲାନି।
ନାହିଁ।
PW4 in prosecution para 5 million.
କଣ କରିବି?
The police came to our village. We 8 people went to the PS. Sama, Sarathi, Kalia, Govinda, Sarpanch, I've been to the case.
After
Police
registration of the
examined
FIR.
after day after occurrence. Day after occurrence.
କୋଉଠି ଆସିଲା କୋଉଠୁ ସେ କହିଲେ
Yes, yes, yes.
ପାରା 4 5 ରେ କହିଲା ପରେ police had examined me
Para, I told,
କୋଉଟା ପଢୁଛନ୍ତି
para 5 pen.
para 5 of cross examination
Hmm.
police had examined me.
Police came to our village. We 8 person went to police station.
ନାଇଁ PW4 କହୁଛନ୍ତି ପରା ସେ
PW4 ର paragraph 8.
8
Sorry, paragraph 5.
Para 4, my lord, para 4, third line. I went along with the
I went
Sarpanch-
along with the
Sarpanch
Sarpanch
of PS
Babu
on the
to the
same day.
PS.
On the
Yeah.
same day after funeral of the dead body. Tapare police came to our village.
We 8 people went to the PS ସେ ଆମ ଅମୁକ ଅମୁକ ଯାଇଥିଲୁ
ସେ ତାକୁ ବୋଲେଇକି ପଚାରିଥିବେ
Yes.
ସେ ମାନେ
ଯାହା ବୁଝିଥିବେ। ତାପରେ ସିଏ ହେଲା ଶବର
ये लीडिंग क्वेश्चन पचार
ये
दियंती
हाँ।
जहाँ कहले हाँ मार दो
ତାପରେ ସେ ଶବର ସେ I don't think that they are conversant with the language. All these barriers would be there. Court ought to have taken caution about this, has not taken care of this. এটা ଗଜପତିରେ ଆଗରୁ ଥିଲା ନା ଏଟା ଦେଖୁଛୁ
ରାୟଗଡା
ନା ପୋଲିସ
ଗଜପତି
ଷ୍ଟେସନ
ଗଜପତି।
ରାୟଗଡା
ଗଜପତି
ଜିଲ୍ଲା
district
ଗଜପତି
ଗଜପତି।
ହଁ କୋଉଠି ସେ ଭାଷା ଶିଖୁଛନ୍ତି ସେମାନେ most of the people they're not aware of.
लैंग्वेज भी ना अलग टाइप हो
And the relation part of the minor, both the PW1 and 4 stated good relation between there is no enmity between the accused and the deceased.
But when you are harping on motive, you should not forget that it is a case which is based on eyewitness account. If it would have been a case of circumstantial evidence that there was good relationship, motive is not established, but eyewitness dying declaration, so a face जदि evidence आसिला ताले भलो relation थिला बेली जो evidence टा आसी गोटे साकी कही दउची
PW1 and 4 stated.
Eyewitness account, oral dying declaration, and witness seen the injury on the deceased.
these are the vital aspects.
Invariably it is seen in, of course this is not on record, but the person was engaged in collecting the dead palm juice. So most of the cases they ask for the juice, and if it is not given, murder takes place.
So, para 10 of the PW2 madam. It is a fact that when Karna told we started the case. Karna is the policeman melody, is the younger brother-in-law of the deceased man.
ये तो फोन मोबाइल फोन पिला ना कौन सा है जॉनी दबो ताकू से जाएंगे
And यार,
ये गोटे कर्ण शबर
Serving in police department.
younger brother-in-law of the deceased man.
हाँ कर्ण शबर पुलिस डिपार्टमेंट रे थिला कर्ण शबर बिलोंग टू लारडा साई
That scenario is altogether different, impossible.
सारथी बिलोंग टू लारडा साई सारथी एंड वन सो आई डू नॉट नो been normal for my years I could be village reported through our something.
Para 10 and 11 is quite.
ये तो मामू पाखु जाएंगे सी अन्य घर वाला
नाम बड़ा पारी जो PW6 is the बड़ा होगा.
नहीं नहीं जहाँ घर
Sarathi Sabar.
I went to the my uncle Sarathi Sabar, not
PW2.
myself. To observe the obsequies. Sarathi का platform.
Sarathi asla nikri asle sabne dead body.
Sarathi accompanied the PW1 to police station.
Ah, right.
Yes.
Sarathi also has seen that
Injuries.
No. Sarathi.
PW6 देखी नहीं?
PW2 is the Sarathi. PW2 has not seen the injury.
अच्छा, PW2 has not.
से सेपटो पड़ेला पुलिस स्टेशन.
Separate.
I know after अच्छा 4 days for अच्छा.
Right.
Amos Sabar seen the
Right.
Amos Sabar
Masaba who carried the body from
along
the
with the
court.
PW1 to house.
That is PW5.
Samus over PW5.
Sentence before reduced.
Non-recovery of the dead body is not fatal.
That is supposedly true.
No. This decision is not applicable because my learned brother has cited one decision. It is in the accused brother of accused as abducted and thereafter the murder and destroyed the dead body. Yeah, here these things prosecution has been.
On the question of dead body recovery or dead body does not arise because the dead body was disposed of. So
And
dead
this
body was
decision
disposed of,
related to
that is a-
accused. Man.
Huh?
My learned brother cited one decision.
Huh.
This decision may not accused was disposed of the dead body.
Hmm.
Where in this case, we are
ଆପଣ
not
accused କୁ ଯାହା ବି ହଉ ଆପଣଙ୍କର ଯୋଉ କଣ୍ଟେନସନ ଟା ଯଦି ଥିବ ଯେ ପୋଷ୍ଟମର୍ଟମ ହେଇପାରିଲାନି ତେଣୁ କୋଉ ଟାଇପ ର ଇଞ୍ଜୁରି ଥିବ ସେଇଟା ଜଣା ନାହିଁ ତେଣୁ
Cause of
dead
death,
body. But that depends on the factual scenario of a particular case. Here, when the dead body was disposed of, either maybe by the accused in some cases, or it is at the threat of the accused, it was disposed of. But fact remains that it has been disposed of. So obviously, purpose delete would not be there. But how do you get over this evidence of these witnesses? We have noted down your points that you said that the solitary eyewitness is PW1 is an interested witness and therefore he cannot be said to be truthful one. And on that day also you said that
except
he
3
did not take his father to the hospital nor lost the FIR immediately, but it was lost 4 days after. So this creates a suspicion on the conduct of PW1 being an eyewitness to the occurrence. Then you said that the dead body was cremated for which real cause of the death could not be ascertained. And when so many villagers were there, merely because the accused persons threatened, they could not have dead body disposed of the dead body. And then your submission was that dying declaration is a suspicious one and weapon was not recovered. These are the points which we have noted down on that day. On the other hand, State Council submission was that the eyewitness version is corroborated by the dying declaration part. And that was before PW4. And he has also stated that the injury on the neck, and that is also what has been stated by PW1, is also seen by 4 witnesses, 3, 4, 5, and 6.
No, even 7.
7.
7 with the
7. After hearing the occurrence, I went to the house of Mumbai and saw cut injuries on his neck.
Then
Oral declaration before PW4 and 6.
So then you say the submission was that at that point of time the body could not have been taken to the hospital because of what has been elicited in the cross-examination of PW1, the time and date and the distance, all these things are that he could not have been taken, and there was life risk also,
Other order.
other hurdles. So the so far as motive part which you said on that day, that there was no motive. Some witnesses have stated that they have stated that since eyewitnesses are there, so motive is not relevant, and your submission that the dead body was not found, we cited a decision. Perhaps you cited that decision that even though the corpus delicti not found, but the evidence otherwise indicates that
2012
death has
one
taken
SEC.
place. Huh?
2012 1 SEC, page 10.
2012
One
1
SEC.
SEC.
Page 10, paragraph 52.
Para 52.
My lord.
ଦେଇଥିଲେ କି ସେଦିନ?
କଣ କହିଲେ?
Therefore, in a murder case, it is not necessary that dead body of the victim should be found and identified. That is, conviction for the offense of murder does not necessarily depend upon corpus delicti being found.
Yes, yes, that is.
That is relied upon, I think, by the trial court. Which
Trial court.
paragraph?
The trial court relies.
Ilahi.
No.
So, इसे डिसीजन में पार्टी ना कौन?
Patina Prithipal Singh and
हाँ,
Prithipal Singh.
Prithipal Singh, अच्छा.
Prithipal Singh and others for the state of Punjab.
State of?
Punjab. ମୁଁ ଦେଇଥିଲି।
citation ଟା ଦେଇଛନ୍ତି, file ଟା ଦେଖୁନ, ବସି ଯାଉଛୁ।
ଆଉ ଦେଇଦେବି।
ନାଇଁ ନାଇଁ, ସେ ଠିକ ଅଛି। ବନ୍ଧା ହେଇଯିବ ତାହେଲେ। ଅଛି ଆପଣଙ୍କ ପାଖରେ? ସେଇ decision ଟା? କୋର୍ଟ ମାଷ୍ଟର ହବାକୁ ହେଲେ ଜଣେ କୋଉ paragraph?
53 minutes. Sorry, 52.
53?
52.
52. Dead body of the human. ତାକୁ ତା ପୂର୍ବରୁ ଆହୁରି ବଢିଆ ଆନାଲିସିସ୍ ହେଇଛି ଯେ ସପୋଜ ଜଣେ ମାରିକିନି ଗୋଟେ ସ୍କ୍ରିନ୍ କୁ ଫୋପାଡ଼ି ଦେଲା, ହଁ ସେ ତ ଡେଡ୍ ବଡି ମିଳିବନି, ବଟ୍ ଏଭିଡେନ୍ସ ଇଜ ଦେୟାର, ମର୍ଡର ହାଜ ଟେକେନ୍ ପ୍ଲେସ୍। ତ ଡେଡ୍ ବଡି ମିଳିଲାନି ମାନେ ନୁହେଁ ଯେ
ମର୍ଡର ହେଇନି।
वो सी अच्छा।
ସେ ରଖି ସ୍କାନ୍ କରିଦେଇଛନ୍ତି, ରହିଯାଇଛି, ସ୍କାନ୍ ହେଇକି ରହିଯାଇଛି।
डिसीजन अछि पर्पस डेलिक्टी नॉट फाउंड, गुडाए साइटेशन दिया है कि अल्टीमेटली गोटे एनालिसिस है कि बात
ଦେଖିଦେବେ।
मनु पात्र मारदेवे पर्पस डेलिक्टी नॉट फाउंड, ओडिशा हाई कोर्ट को आसिकिन हमरी क्लिक कर देबे मोदी जो डिसीजन।
ଏଇ ଜଜମେଣ୍ଟରେ ସେଟା ଲାଷ୍ଟ ଟାଇମ୍ ଯଦି ହେଲା ସ୍କାନ୍ ହେଇକି ରହିଯାଇଛି। ମୁଁ ସେଟାକୁ
ना मार्केट दरकार दैट इज देयर। So what goes in his favor that what happened prior to the occurrence, just before the assault, because the relationship was good. So what happened on that particular moment? Why they
Yes,
assaulted,
yes.
that is not on record.
That is not.
No,
but-
No evidence obvious.
No,
Number two, the death has taken place after 5 hours. As per the
Yes,
evidence,
5 p.m.
10ଟା ବେଳକୁ
ଘଟଣା
ଘଟଣା ହେଇଛି, 10ଟା ବେଳକୁ ତାଙ୍କ oral evidence ଦିଆ and he was not of course shifted to the, so that may be also one of the reason for which death has taken place. So how many blows have been given? Also there is
2 injury PW
Two injuries they have seen
Seen.
and both बोलिके से कौच PW1
ना PW1 2 injury कहले
ना 2 injuries अन्य माने कहले ना से कहला चेज करी जो both of them have
assaulting.
but
one cut injury or 2 cut injury
2 cut injury.
2 cut injury.
whether they were both holding the kati or one was holding the kati, the
After
other
what
was
say PW1 both are ending now.
खाली किसी को नहीं, they were
PW
giving
Yes, yes.
healthy blows खाली.
PW6 कहछि 2टा injury.
नहीं हाँ सर 2टा injury अच्छी but PW1 कहला कि
PW1 कहला both the accused person chasing my father were assaulting Kati on the neck of my father.
No, assault.
What has been on each part रे जो आई विटनेस पार्ट रे जेरा कौन है जी?
तापर कहले both the accused person were giving Kati blow on the neck of my father.
तारी ऊपर किसी क्रॉस एग्जामिनेशन है जी?
ना आरे
मतलब स्पॉट ऑपरेट है कि PW5 टे जोटा occurrence
ना 5
ना
नहीं
PW1 जो कहला
वन पता
बियन में Kati blow रे करथले तापर किछि पता
चेजिंग जा जणा पड़छि ताकू both the accused person chasing होउछि सेटा गोटे वर्ड एवं
Yes.
ताकू assaulting
both
on the
were assaulting
neck.
giving Kati blow on
काती
the
blows on the neck.
neck of my father.
हाँ तेणु से चेज होउछि काती ब्लो होउछि नेक
दीटा injury अछि
हाँ
neck अछि और दीटा injury अछि
that is stated by
PW6.
PW6.
yes. I went to the house of deceased and found 2 cut injury on his neck side. ना
on his right
neck.
side
right side ने
neck. तापरे it is not a fact that I have not seen the cut injuries. पचरा है जी, he has reiterated on the neck of my brother. It is not a fact that I had not seen the injury on the neck of my brother. So time and again he has been put this question.
वन 164 ର ମଧ୍ୟ ୱିଟନେସ୍ ଗୁଡାକ ସବୁ
Consistent.
କହୁଛନ୍ତି ଦୁଇଥର ଲେଖା
ଦୁଇଥର।
ଦୁଇଟା ଲେଖା that's it. ଗୋଟେ ଗୋବିନ୍ଦ ଶବର କିଏ ଆଉ ଗୋଟେ ହଉଛି
PW7.
PW7 में
PW7
Miller.
my name is she କଣ କହୁଛି Court re kon kହୁଛି?
After hearing the occurrence, I went to the house of Dumbai Sabar and saw cut injury on his
Got
leg.
injuries kହୁଛି on the neck. It's more than one. ଆଉ ବାକି ରହୁଛି PW ଆଚ୍ଛା ସେ ଗୋଟେ ହଉଛି କାଳିଆ ସବର କି ଏକ୍ସାମ ହେଇଛି ଦୁଇଥର କାତି ମାଡ଼ ହୋଇଥାଏ ଆମେ ଦେଖିଲୁ କାଳିଆ ସବର
କିଏ?
Kalia Sabar.
PW3. PW3 months.
3?
Hey, Kalia sir.
Kalia Sabar stated that I saw
lying with injuries khuଛି
Injuries is on his right. Vital part of the body, weapon knowledge of it, the vital source and that. Medical income from and death is not very bad. Might be on the part of the 14 vessel. But one that's what it.
Part of the other injuries and other parts of it. And those are not. Surface of injury. The feeling of injury. Positive and the vital part of the body because not and very and that's the yes, really. We'll just come. Criminal Appeal number 126 of 2000. Appellants Lingu alias Lingaras Karji alias Huya and Sali Sabar faced trial in the court of London Additional Session Judge Gajapati Parala Khemundi in Sessions case number 14 of 1998 for commission of offense under section 302 by 34 and 506 by 34 of the Indian Penal Code on the accusation that on 19th November 1997 at about 5 p.m. at village Rongoda at Purna Sahi Jangli, they committed murder of Dumbai Sabar, bracketed like them to hereafter the deceased, in furtherance of their common intention. And say private secretary would accuse simultaneously in the proceeding parallel. And on that night, also they threatened PW 1 Somnath Sabar, the son of the deceased. Charger
Attend was in the night at 10 o'clock.
506. With injury, with intent to cause alarm to him and to dispose of the dead body of the deceased and not to report the matter before the police station in furtherance of their common intention. The London Trial Court, by judgment and order dated 11/5/2000, found the appellants guilty under section 302, 506 by 34 of the Indian Penal Code and sentenced each of them to undergo imprisonment for life and to pay a fine of rupees 15,000 each in default to undergo RI for 2 years under section 302 by 34 of the Indian Penal Code. However, no separate sentence was awarded for their conviction under section 506 of the Indian Penal Code. The prosecution case, as per the first information report lodged by PW1 Somnath Sagar before the officer in charge of Rayagada Police Station on 23/11/1997, in short is that on 19/11/1997 in the evening hours at about 5 p.m. while the deceased had been এরকম কাটটি palm
Palm date to court, palm date.
palm
Date.
date DAT palm date to এটা collect করি
Collect
to collect palm date
juice.
comma the PW1 had been to attend call of nature at that time. PW1 heard the shriek of the deceased and the deceased was shouting to help him. Accordingly, PW1 rushed to the place from where he heard the shout. And he found that both the appellants were chasing and assaulting the deceased. Seeing PW1 at the spot, both the appellants fled away. PW1 found injuries on the person of the deceased and he was lying under a tree. He rushed to his uncle Shan Sabar bracketed PW5 and called him to the spot, and both of them shifted the deceased who was in an injured condition to the house. After reaching there, the deceased disclosed before the family members that both the appellants had killed him. Killed, not really, had assaulted him, had inflicted court injuries on him.
Only hacked him.
Hacked him. It is stated that the deceased could not be shifted to the hospital, and at about 10 p.m. he succumbed to the injuries. After some time, both the appellants came to the house of PW1 and threatened him not to report the matter before police, and further threatened to dispose of the dead body in the early morning, otherwise he would face dire consequences. Accordingly, PW1 assured them to cremate the body, and with the help of co-villagers, the dead body was cremated in the morning. The appellants guarded the PW1, for which he could not proceed to the police station, and on the pretext of performing obsequious ceremonies of the deceased father, PW1 came to the house of Sarathi Savar, to the house of his maternal uncle, Sarathi Savar, bracket लिख देंगे PW2. And then the matter was reported at the police station. The report was scribed by PW2 on the information of PW1, and it was presented before the officer in charge of Rayagada police station, who registered Rayagada PS case number 41 of 1997, dated 41 dated 23/11/1997 under section 302/506/34 of the Indian Penal Code against both the appellants. Subparagraph. PW 8 Abhimanyu Nayak, the officer in charge of Rayagada police station, after registration of the case, examined the witnesses, visited the spot, and seized old torn lungi of green color lungi stained with blood, one chadar and production by Tilanki Shabar, bracket PW4 na, PW4, the wife of the deceased, as per seizure list exhibit 3. He also seized bloodstained earth, sample earth, branches of a tree stained with blood, one Gudaku Daba, as per seizure list exhibit 4. He also sees some bone pieces from the burial ground where the dead body of the deceased was burnt, as per seizure list exhibit 5. On 24/11/1997, the IO arrested both the appellants and forwarded them to court on 25/11/1997. He also seized the wearing apparels of the appellants as per seizure list exhibit 6 and dispatched the seized articles to RFSL Berhampur for chemical examination. He also sent the wearing apparels of the deceased to the RFSL Berhampur through court and handed over the charge of investigation to PW9 is Dharma Rao, his successor, on 8/1/1998. PW9, after taking over the charge, also examined some witnesses played before the London SDGM. SDGM Parla Khemudi for recording of the statements of 4 witnesses under section 164 of CRPC. He also sent the bone pieces to the State Forensic Science Laboratory, SFSL, বোনটা ঠিক হয়েছে State Forensic Science Laboratory, Bhubaneswar, and after completion of investigation, he submitted charge sheet against the appellants. A Barkala charge sheet final conta on 15 to 1998 under section 302/506/34 of the Indian Penal Code. After submission of charge sheet, the case was committed to the Court of Session following due procedure, where the London Trial Court framed the charges as aforesaid. And since the appellants pleaded not guilty and came for trial, the sessions trial procedure was resorted to prove their guilt. In order to prove its case, the prosecution examined 10 witnesses. The prosecution also exhibited 9 documents, and also proved 4 material objects. The defense plea of both the appellants was one of denial. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold that injuries on the deceased on the neck has been noticed by PW1, 5, 6, and the dead body was cremated. And from the available evidence on record, there is no suspicion in any manner that death of the deceased has been caused being assaulted by the appellants by means of kati. The London Trial Court also accepted the evidence of PW4 and PW6 coupled with who have stated about the dying declaration, coupled with the direct evidence of PW1. After assessing the evidence of PW1, the dying declaration, and the court injuries noticed by the witnesses on the right side neck of the deceased, the London Trial Court came to the conclusion that there is absolutely no suspicion to conclude that the appellants have committed murder. Stop. Though the London Defense Counsel raised contention regarding delay in lodging the first information report, but the London Trial Court, after assessing the evidence on record, came to hold that delay in lodging the FIR stands sufficiently explained, and the prosecution has proved this point with great satisfaction. The London Trial Court further held that the evidence of PW1 coupled with the other circumstance it is apparent that the appellants are the authors of the crime and they have committed the murder of the deceased by giving kati blows on his neck. And accordingly found both of them guilty under section 302 to 506 by 34 of the Indian Penal Code. Mr. Malaya Kumar Swain, Land Council, appearing, acha, eta likhi diyantu, subpara count. During pendency of the appeal, say the order of abatement, order during pendency of the appeal, the appellant number 2, Sali Savar, died. And in that respect, the London Council for the State produced the written instruction from the inspector in charge of Rayagada Police Station, dated 12/8/2025. Since no legal heirs of appellant number 2 filed an application seeking leave to continue the appeal within the prescribed period, taking into account the proviso which corresponds to 435 of BNSS on 14/8/2025, we passed the order regarding the abatement of the criminal appeal so far as appellant number 2 Sali Savar is concerned. Mr. Malay Kumar Swain, Land Council, appearing for the appellant number 1, Lingu alias Lingaraj Karji alias Buya, contended that PW1 is none else than the son of the deceased, and he is a highly interested witness, and his solitary evidence should not be accepted to hold the appellant guilty. It is further argued that the conduct of PW1 is very suspicious, inasmuch as even though the deceased had sustained injuries on the vital part of the body, like neck, as per his version, but he has not shifted the deceased to the hospital, nor lodged any first information report immediately, and it was lodged 4 days after the occurrence. It is further argued that when number of villagers were available merely because the appellants gave threat to him to cremate the dead body, he should not have the disposed of the dead body, and by disposing of the dead body, the real cause of the death of the deceased could not be ascertained. it is also stated that dying declaration stated to have been made before PW1, PW4. These are not now okay. 6 and 6 is very suspicious. And when injuries were stated to have been caused on the vital part of the body like neck, it was not expected that the deceased would make dying declaration. He further argued that though according to PW1, the weapon of offense was kati, but the same was not recovered. And he further argued that there is no material available on record as to why the two appellants assaulted the deceased on the date of occurrence, particularly when the evidence on record indicates that there was good relationship between them. It was further argued that what transpired prior to the assault is also not available on record. The death was not instantaneous, and since the deceased could not be shifted to the hospital in view of the time when the assault took place and the death took place, and the situation of the hospital, even if it is held that the appellants assaulted the deceased, the conviction under section 302 IPC was not justified, and the conviction should be altered to one under section 304 part 1 of the Indian Penal Code. The Land Council for the state, on the other hand, supported the impugned judgment and argued that merely because PW1 is related to the deceased, that cannot be a ground to discard his evidence, particularly when he has vividly narrated how the occurrence has taken place and how the deceased was shifted from the place of assault to the deceased, how he made the dying declaration, and when he died, and how the appellants threatened him with dire consequences for which the first information report could not be lost. Nothing has been brought out in the cross-examination to disbelieve the evidence of PW1 as an eyewitness to the occurrence, and therefore the Learning Trial Court has rightly placed reliance on the evidence of PW1. Stop. It is further argued that the evidence of PW1 that the assault was made on the neck of the deceased by a kati is getting corroboration from the evidence of PW 3, 4, 5, 6, and 7, who have stated to have seen injuries on the neck of the deceased. It is further argued that in the cross-examination, PW1 has stated that why steps could not be taken to shift the deceased to the hospital immediately after the occurrence And the London Trial Court has also accepted the same. He further argued that on account of delay, on account of threat given by the appellants, not only the body was disposed of, dead body was disposed of, but the first information report could not be lodged immediately after the occurrence. And the London Trial Court has rightly held that the prosecution has satisfactorily explained the delay in lodging the first information report. He argued that the dying declaration made before 1, 4, and 6 are consistent, and nothing has been brought out that the deceased was not in a position to speak anything. He further argued that the dead body, merely because the corpus delicti was disposed of because of the threat given by the appellants, and postmortem could not be held, that cannot be a ground to disbelieve that homicidal death of the deceased has taken place in view of the consistent evidence available on record. Reliance has been placed in the case of Prithipal Singh and others versus State of Punjab and another, reported in 2012 1 Supreme Court cases, page 10. The Land Council further argued that since the assault was made on the vital part of the body like neck, and the evidence of the witnesses indicates that there was 2 blows on the neck. Therefore, the London Trial Court has rightly found the appellants guilty under section 302 of the Indian Penal Code. Stop. Next part. Adverting to the contention raised by the London Council for the respective parties, there is no dispute that the prosecution has examined PW1, the son of the deceased, as the sole eyewitness to the occurrence. Law is well settled that the evidence of a solitary witness is can be accepted, and conviction can be sustained on such testimony if it is found to be clear, wasn't trustworthy, and above board. It is also the settled position of law that merely because a witness is related to the deceased, the same cannot be a ground to discard his evidence. Rather, the related witnesses are not likely to implicate someone falsely, leaving the real assailant. In the case in hand, PW1 has specifically stated that his father, deceased, had been to Purna Sai jungle to cut date palm and juice, and he had also been to attend the call of nature. And while he was attending the call of nature, he heard sound of his father saying, "Mote sahajya karo ke aho." And he, hearing such sound, he came near his father and saw both the appellants were chasing the deceased and assaulting him Vaikati on the neck. He stated that when he arrived near the deceased father, both the appellants fled away. He found that the deceased had sustained bleeding injuries and was falling on the ground, and he called his uncle Sham Shavar, bracket PW5, and he, along with PW5, brought the deceased to the house. And on arriving in the house, the deceased told his mother, bracket PW4, and other family members that both the appellants killed him. He specifically stated that at about 10 p.m. on that night, the deceased died, and in the early morning, while they were crying, both the appellants came to their house and asked them to dispose of the dead body immediately, or else they would kill the family members. And the appellants further threatened not to report at the police station. And accordingly, out of fear, they disposed of the dead body of the occurrence. PW1 has specifically stated that after the occurrence, out of fear, he could not report the occurrence before the police station and went to the house of his uncle, Sarathi Savar, bracket PW2, to observe the obsequies, and thereafter came to the police station with PW2 and reported the matter. In the cross-examination, the defense counsel has elicited that it takes about 5 minutes to reach bust of Lanja Padar from the village, and that main road leads towards Rayagada to one side and to Paralakhemundi to the other side, and there were buses, tractor flying from Rayagada to Paralakhemundi. It is the contention of the learned counsel for the appellant that if bus services were available and the bus stop was nearer to the village, the PW1 and his family members would have taken the deceased to the hospital. However, there is no evidence that the bus services were available at that point of time when the deceased sustained injury and was brought to the house from the spot by PW5 and PW1 and PW5. Rather, it has been elicited in the cross-examination that on that day, PW1 could not go to the police station as it was already evening, and they have to cross hills in the night. The PW1 has specifically stated that it was evening time and there was slightly darkness at the time when they brought the deceased. Therefore, they had to cross the they had to cross the hills. Therefore, the submission of the learned counsel for the appellant that no plausible explanation has been given by prosecution as to why the deceased was not shifted to the hospital and why the report was not lodged in the police station in that night has no substance. The London Trial Court has rightly assessed the timing of the occurrence, the situation of the village, the distance of the hospital and police station from the village, which, as per the formal affair, is 20 kilometers away. The Land Council for the petitioner submitted that since number of persons were available in the village, the threat which stated to have been given by the appellants would not have been a factor not to report the matter before the police station and to dispose of the dead body. However, evidence of PW1 is very clear that in the morning, the appellants came to his house and told him to dispose of the dead body immediately, or else they would kill him. And they further threatened not to report the matter at the police station, and that out of fear they disposed of the dead body of the deceased. It cannot be lost sight of the fact that it was a rural area, and the how a person would react after seeing the deadly assault on the father and to the threat of the given by the appellants would differ from person to person. Therefore, there is no unnatural conduct on the part of PW1 in the given circumstances, in the factual scenario, not reporting the matter to the police station immediately and disposing of the dead body. Nothing further has been elicited in the cross-examination to disbelieve the evidence of PW1. Moreover, it appears that the evidence of this eyewitness PW1 is getting corroboration from the evidence of PW4 and 6, who have also stated about the dying declaration of the deceased. PW6 is none else than the widow of the deceased, and he has stated that on the date of occurrence, when her husband was brought to the house by Somnath bracket like to PW1 and Syama bracket re PW5, comma, her husband was alive at that time and told that the appellants assaulted him. She further stated to have noticed cut injuries on the neck of the deceased. She further stated that in the same night at about 10 p.m. the deceased died. In the cross-examination, she has stated that the deceased was brought to the house at about 5 p.m. from the forest, and she was present in the house when the deceased was brought and kept in the house on the floor, which was stained with blood. And she further stated that there was cut injury on the neck of the deceased, and the head was not severed from the neck, but it was bent, and the deceased could not tell anything more. The evidence of PW6 is also that when he hearing about the occurrence, he came to the house of the deceased, he noticed 2 cut injuries on the right side neck. And PW6, who is the elder brother of the deceased, stated that hearing about the occurrence, he came to the house of the deceased, found 2 cut injuries on the right side neck, and on being asked as to what happened, the deceased told that the appellants killed him. In the cross-examination, he has stated that on hearing that his brother has died, he came to the house of his brother and found that the family members were crying in the house of the brother. Specific suggestion has been given that the deceased had not told that the appellants had killed him, but he has denied such suggestion. Nothing further has been elicited in the cross-examination of PW6. Therefore, the oral evidence of PW1 who have seen the direct assault on the deceased is getting corroboration from the dying declaration, which is stated to have been made not only before PW1 but also before PW4 and PW6. These, though the evidence of these 2 witnesses was also challenged on the ground of their relationship, but as we have already held that merely because they are related as the wife and the elder brother of the deceased, when their evidence inspires confidence of this court, it cannot be rejected. Stop. The delay in lodging the first information report was also argued by the learned counsel for the appellant. But PW1 has very categorically stated, not only in the first information report itself, but also in his evidence as to why the report could not be lodged earlier. On account of threat and also fear, he specifically stated not to have proceeded to the police station immediately, and he went to the house of his uncle, maternal uncle, Sarathi Sabar, and with him, he went to the police station after 4 days of the occurrence, and as per his version, oral version, PW2 reduced the report into writing and it was presented in the police station. The London Trial Court has relied upon the decisions of the Honorable Supreme Court in case of Jadunath Singh versus Uttar Pradesh, reported in AR 1972 Supreme Court 116, wherein it has been held that time, distance of the police station, non-availability of the conveyance, danger of the accused armed with weapon, and relative circumstances are the deciding factors whether the delay in lodging the FIR has been properly explained or not. Reliance has also been placed in the case of State of Uttar Pradesh versus Manohar Lal, reported in AR 81 Supreme Court 2073, wherein it has been held that the question of delay in lodging the first information report is to be considered in the background of human factors involved, such as time required by the person concerned to compose before taking a decision relating to the course of action. Reliance also placed in the case of Arpen Joseph versus State of Kerala, reported in AR 73 Supreme Court, page 1, that delay in lodging the FIR is not always fatal to the prosecution case. It only gives rise to suspicion, which put the court on guard to look to possible motive and explain all the delay. Therefore, in view of the evidence of PW1, the surrounding circumstances, we are of the view that the London Trial Court is quite justified in holding that delay in lodging the FIR has been sufficiently explained by the prosecution with great satisfaction. Stop. The contention of the London Council for the appellant that the weapon could not be recovered and is not a ground to disbelieve the prosecution case.
On this point, recent judgment number, Supreme Court, that is 2025, INSC is 47.
The London Council for the state has placed reliance in the case of
Govardhan and another versus State of Chhattisgarh.
Govardhan and another versus State of Chhattisgarh, reported in 2025,
INSC
INSC
is 47.
47.
And
Yes.
Rakesh versus State of Uttar Pradesh,
Rakesh versus State of Uttar Pradesh,
AR 21,
AIR 2021,
Supreme Court,
SC
3233.
3233.
Tell that recovery of the weapon of offense is not a sign for none for recording the conviction.
Wherein the Honorable Supreme Court has categorically held that recovery of a weapon of offense is not a sign qua non for holding a person guilty.
But that is direct evidence to be.
Particularly when there are direct evidence in this case. So, it may so happen that in a particular case, the accused persons may dispose of the weapon of offense, throw it in stream of water, and if in such a situation the insistence would be made that the recovery of the weapon has not been made, and the prosecution case is to be disbelieved on that ground, then no prosecution may succeed, particularly when the evidence relating to the direct evidence relating to the assault on the deceased is available. Therefore, the submission of the learned counsel for the appellant on this score is discarded, is not acceptable. Stop. It is of course correct that the dead body was disposed of and the corpus delicti not found, but as rightly the London State Council placed reliance in the case of Prithipal Singh, wherein it has been held that in a murder case, it is not necessary that dead body of the victim should be found and identified for, in other words, the conviction of the offense for the offense of murder does not necessarily depend upon corpus delicti being found. The corpus delicti in a murder case has two components: death as a result and criminal agency of another as the means. Where there is direct proof of one, the other may be established by the circumstantial evidence. In the case in hand, when the direct evidence of PW1 coupled with the other evidence is available and the witnesses have specifically stated on what part of the dead body the injuries were there, merely because the dead body was cremated on account of threat given by the appellants, it cannot be a ground to disbelieve the prosecution case. Therefore, on the basis of the eyewitness account of PW1, the evidence of dying declaration which has been deposed to by PW4 and 6, the injuries on the neck as noticed by PWs 3, 4, 5, 6 and 7. We are of the view that the London Trial Court has rightly held that the appellants are the author of the commission of murder. Stop. The next question arises regarding as to whether the prosecution has proved the case under section 302 of the Indian Penal Code. For proving the culpable homicide, culpable homicide to be a murder, section 300 of the Indian Penal Code states about 4 clauses, which are as follows. In the case in hand, there is evidence on record adduced by a number of witnesses that there was good relationship between the appellants and the deceased. Who are those witnesses? Please tell us so that we can mention here.
PW1 and 4.
PW1 has stated
And 4.
in which paragraph? Acha. PW1 has stated in the cross-examination that they were in good terms with the appellants prior to the occurrence. Anybody else?
Similarly, PW4.
PW4 has stated in the cross-examination
Para 7
that the appellants had no bad relationship with the deceased. Anybody else? Stop. The evidence of PW1, the eyewitness to the occurrence, is not clear actually what happened prior to the assault on the deceased. PW1 came to the spot only when he heard the shout of the deceased. Admittedly, the death took place 5 hours after the occurrence, and thus the death was not instantaneous. The nature of blows given and the impact of such blows on the neck of the deceased is also not on record because the post-mortem could not be conducted. There is every possibility of huge loss of blood may be a contributory fact to the death of the deceased. In view of all these circumstances, we are of the view that the conviction under section 302 of the Indian Penal Code is not justified, and accordingly we alter the conviction to one under section 304 part 1 of the Indian Penal Code. As for the order passed by this court on କେବେ କହିଥିଲୁ ଆମେ ଆପଣଙ୍କୁ ଆଣିବା ପାଇଁ ଯୋଉ ଇୟର 9/9/2025, we asked the Learned Counsel for the state to obtain instruction regarding the financial condition, health condition, and also if there is any criminal antecedent against the appellant. Today, the Land Counsel for the state has also produced the written instruction received from IIC Rayagada Police Station dated 17/9/2025, wherein it is stated that the widow of the deceased Lakshmi Shabar is alive and
Appellant number 2 was expired.
Acha, wife of the appellant number 1, na? Appellant number 1 is alive and staying with her family and having 5 sons, and they were doing cultivation work, and the health condition of the appellant number 1 was directed to be released on bail by this court as per order dated 29 2009 is good, and financial condition is poor, and there is no criminal antecedent except the present case. Stop. The occurrence has taken place in the year 1997, and in the meantime 28 years, about 28 years, about 28 years have passed. The appellant was aged about, what was his age at the judgment? Is the accused statement. Was 30 years at the time of pronouncement of judgment, and it must be reaching around 60 years, no? 60 years. Further considering that the petitioner belonged to tribal area, in view of the passage of time, while altering the conviction to 100 section 304 part 1, we sentence him to imprisonment RI for 7 years. It appears that the appellant was taken into judicial custody on 25/11/1997, and from the trial court record, it appears that he was never released on bail during trial. However, during pendency of the appeal, he was granted bail wide order dated 20/9/2000, and therefore the petitioner has undergone sentence of about 2 years and some months. In view of the sentence imposed, the petitioner shall surrender to before the Land Trial Court within a period of 4 weeks to serve out the remaining sentences. Failing which, the Land Trial Court shall take coercive steps in accordance with law for his arrest and remanding him to judicial custody. Put a note of appreciation on the efforts of Mr. Swine and Mr. Nayak.
Pardon my